Hello, and welcome to Organized, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and today we're wrapping up our series on partnerships with a discussion on disassociation and dissolution. Partnerships, by their nature, are dynamic business structures that evolve as partners join or leave, or the partnership itself concludes its scope of business. The process of disassociation and dissolution address these changes by providing a legal framework to manage transitions while protecting the interests of partners, creditors, and third parties. And so in this lecture, we'll discuss the key events that trigger disassociation and dissolution. We'll talk about the legal and practical consequences of disassociation and dissolution. And we'll talk about how these processes play out under the Revised Uniform Partnership Act. Disassociation occurs when a partner exits the partnership. Under Revised Uniform Partnership Act Section 601, there are several events that can trigger a disassociation. One is a partner's voluntary decision to withdraw. A partner could also be expelled by a unanimous vote of the other partners, or by a court order, by bankruptcy, or by the partner's death. Disassociation may also occur if an event specified in the partnership agreement arises, such as the completion of a defined term or project. So disassociation can be either voluntary or involuntary. As mentioned, in a voluntary disassociation, the partner chooses to leave the partnership. So a partner may decide to retire or pursue other business opportunities. Involuntary disassociation typically involves circumstances where the remaining partners or a court determine the partner's continued involvement is detrimental to the partnership. Examples of involuntary disassociation include situations where a partner breaches fiduciary duties, where a partner becomes permanently incapacitated, or when a partner engages in conduct that harms the partnership's business. The consequences of disassociation depend on whether it is rightful or wrongful. A disassociation is considered rightful if it aligns with the partnership agreement, or if it occurs for reasons permitted under the Revised Uniform Partnership Act. Wrongful disassociation, on the other hand, occurs when a partner exits in breach of a partnership agreement or at a time that disrupts the partnership's business. Wrongfully disassociating partners may be liable for damages caused by their departure. Dissolution marks the beginning of the end of a partnership. It is sometimes called dissolution and winding up because dissolution is the beginning of the process of ending the partnership's affairs, and ultimately ending in its termination. Under Revised Uniform Partnership Act Section 801, dissolution can occur for several reasons, including the unanimous decision of the partners, the expiration of a fixed term, or the completion of a specific project. If a partnership's business becomes unlawful, a judge can decide that the partnership must be dissolved. And dissolution may be triggered by a party's disassociation, especially under the aggregate theory of partnership or in a two-person partnership, as even under the entity theory of partnership, the remaining partner cannot continue a partnership alone, because a partnership is always comprised of two or more persons. Dissolution does not mean the partnership immediately ceases to exist. Again, it's the beginning of a process of winding up that will end with termination. During the period known as winding up, which begins with dissolution, the partnership's activities are limited to those necessary for closing its business. Dissolution activities include paying off debts, liquidating assets, and distributing any remaining profits to the partners. The partnership continues to exist as a legal entity during winding up, and that ensures it can fulfill its obligations and manage its terminal affairs effectively. And so we see that winding up is a critical stage in the dissolution of a partnership. Partners who have not wrongfully disassociated participate in the winding up process, and their efforts should be compensated separately. The tasks involved in winding up include collecting and selling partnership assets, settling outstanding debts and obligations, and distributing any remaining proceeds according to the partner's profit-sharing agreement or Revised Uniform Partnership Act default rules. For example, Revised Uniform Partnership Act Section 804 provides that the partnership's liabilities must be satisfied before any distributions can be made to the partners, and this ensures that creditors are paid first. This protects the interests of creditors, and it maintains trust in the partnership structure writ large. Any funds remaining after creditors are paid are then divided up among the partners based on their respective shares, and this is sometimes referred to as the distribution of the residual. The partnership agreement should define how these shares are distributed. If not, the default rule is equal distribution. The partnership agreement plays a crucial role in shaping the process of disassociation and dissolution. By specifying the terms under which partners can disassociate and the procedures for winding up, the agreement provides clarity and reduces the likelihood of disputes. For example, an agreement might require a departing partner to provide advance notice or to provide the steps for valuating and buying out partnership shares of disassociating partners. Similarly, the agreement can define what constitutes a triggering event for dissolution, and it can talk about how partners will manage the winding up process. Disassociation and dissolution are often accompanied by emotional and financial challenges. Partners leaving a business may feel a sense of loss or conflict, while remaining partners must navigate the transition effectively and efficiently. Disputes over valuation, liabilities, or responsibilities can exacerbate these tensions. And for this reason, having advance directives like a clear, well-drafted partnership agreement can help mitigate these problems in advance. And even if not, clear communication and mediation or legal intervention helps resolve conflicts and protects the partnership's remaining interests. From a practical standpoint, it's essential to address disassociation and dissolution proactively. Partners should regularly review and update their partnership agreement to reflect the current realities of their business. Businesses end, and by anticipating potential issues and establishing clear procedures for when it does, partnerships can minimize disruption and thus ensure a smoother transaction when inevitable changes occur. In conclusion, disassociation and dissolution are integral to the life cycle of a partnership. They provide mechanisms to address changes in the partnership's composition and its eventual closure. These processes, whether guided by the revised Uniform Partnership Act default rules, its mandatory rules, or the partnership agreement, they balance the interests of partners, creditors, and third parties while ensuring fairness and accountability. And so, as you reflect on this last lecture in this season on partnerships, you might consider how you might approach drafting or revising a partnership agreement to address disassociation and dissolution effectively. And you might consider why people don't do this. It tends to be hard to think about end-of-life cycle events, but it's important for lawyers to be proactive in addressing them before they arise while things are still going well. Thank you for joining me for this episode of Organized, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and I'll see you for our final episode of the series when we talk about partnership taxation to wrap up our season on partnership. See you then.